There are certain parts of the Constitution that everybody needs to know. This video will cover some parts of the Constitution. It's not going to cover every part that a person will need to know in their life or lifetime, but it'll cover some of the big ones. The first three sections of the U.S. Constitution create the three branches of government. The legislative to write the laws, including the national budget. The executive to execute the laws, and that includes spending the money allocated in the national budget. And the judicial to apply the laws in particular cases and to hear petitions and complaints. If you did not know where the three branches came from, it's the Constitution. The right to remain silent. That's a right that everybody knows they have. Maybe they don't know it's in the U.S. Constitution, but they've heard it so many times on TV, they know it's a right. But it's not always so simple. In criminal enforcement or criminal prosecution, the right to remain silent works differently than in a civil context. That's why it's important to know the difference between civil and criminal proceedings. In a criminal investigation, the police cannot force somebody to answer questions. The police cannot hold somebody for refusal to answer questions, and the police must stop interrogations when the person being questioned insists on stopping. Also, in a criminal case, during court proceedings, the accused cannot be forced to be a witness. Nobody can say, "Judge, we call the defendant to the witness stand." Whether or not the defendant in a criminal case testifies is completely the decision of the defendant. And if a criminal defendant does not talk or testify, nobody can make a comment about it. The jury is explicitly told that no conclusions can be made from the defendant's choice to say nothing. If a prosecutor or another witness makes a comment about it, it could result in a mistrial. Oftentimes when jurors are chosen to sit in a criminal case, they will be questioned about whether or not they can honor a person's right to remain silent. They will be asked, for example, if the defendant does not testify, will you hold that against them? If they are not able to give the defendant the benefit of the doubt in his decision not to testify, then they will probably not be allowed on the jury. They will be told that they can make no conclusions from the defendant's decision not to testify, and they will be told that they cannot assume an innocent person would always testify. However, during a criminal case, if the defendant does choose to get on the witness stand, then the defendant must answer all questions. The defendant is not allowed to pick and choose which questions are convenient to answer once they get on the stand in a criminal case. Almost none of this applies in a civil case. So even if a person is charged with a crime, they can still be called to testify in a civil case. Once on the witness stand, they have the right to refuse to answer questions which might cause them to be jailed or imprisoned. But if they refuse to answer questions, any comments can be made by anybody, and any logical conclusions can be made. Here is an example. If a pilot is suspected of being intoxicated while flying, he might be detained by the police. He has the right to refuse to answer all questions, except what's your name and certification number. Maybe. But he has the right to refuse to answer all questions like, how much have you had to drink? What have you had? What kind of drugs have you taken? What kind of prescriptions are you prescribed? Are you able to pass a field sobriety test? These kinds of questions he does not have to answer. In criminal court, he does not have to say a word, and nobody can hold it against him. But when the pilot sues the airline for firing him, in the civil suit, the airline's lawyer can call the pilot to the witness stand, and the airline's lawyer can ask him, how many beers did you have in the week before flying that plane? And if the pilot refuses to answer, then the judge or jury in the civil case can assume he had a lot of beers and decide he was fired for a good reason. Also, Anything that the pilot in the civil case says can be used against the pilot in the criminal case. That's why it is often better for criminal defendants to stay out of civil lawsuits. Due process. In two separate places, the U.S. Constitution provides that no person shall be deprived of life, liberty, or property without due process of law. In one place, the provision applies to the federal government. In another place, the provision applies to the state governments. But in total, the Constitution says it twice. There are two aspects to due process: substantive and procedural. Substantive due process applies to general laws passed by any branch of government. For example, if Congress passed a law prohibiting trees, saying that nobody can plant a tree or grow a tree, or passed a law saying everybody's taxes have to be 100% of their income, then the courts might consider it a violation of substantive due process. This is not something most people ever have to use or know, so we will not spend any more time on it, and it will not be on any test this semester. But procedural due process is very different. Procedural due process is more important because it affects nearly every interaction between the government and individuals. Imagine if the government sent somebody to prison for 99 years and never gave them a day in court. Imagine if the government started taking child support out of somebody's paycheck without ever giving them a chance to take a paternity test. Imagine if the FAA revoked somebody's certification and never told them why or gave them a chance to argue for saving the certification. And the examples could go on and on. The right to procedural due process guarantees every person a fair chance to be heard, especially in court. There are two basic components to procedural due process: notice and the right to be heard. So, once again, due process can be broken into substantive and procedural. And procedural due process has two components: notice and the right to be heard. Take the example of somebody being locked up for 99 years and never getting a trial. Due process means the accused would be informed of the charges against him and then given a fair chance to defend himself against the charges. Due process is intimately connected to several specific steps in Texas criminal procedure, such as receiving a copy of the charge, receiving a court-appointed lawyer, presenting evidence at trial for defense, and appealing a conviction. Take the example of somebody losing child support from their paycheck and never having the chance to take a paternity test. Due process means the man would be given notice of the paternity claim and told what court to go to. And due process would mean the man would have a chance to present evidence proving he is not the father. Finally, the person who is losing their FAA certification should also be given notice and an opportunity to be heard. The person who has the certificate should receive notice that the FAA is considering revoking the certificate and told when and where they can resist the revocation. Due process includes some reasonable chance to appeal any FAA decision. Let's look at due process in the context of the stages of a lawsuit, which are 1. Filing a petition, 2. Service of process, also known as citation, 3. Answer, 4. Discovery, 5. Motions, 6. Trial, 7. Judgment, 8. Appeal, and 9. Collections. The first notice that a person gets when they are sued is step number 2. The person being sued will receive a written document called a citation or process or a summons or maybe some other name. But whatever it is called, it will inform the person they have been sued and what court the lawsuit is in. The notice will have a copy of the lawsuit attached. That is the notice portion of due process. Once a person has received notice that they have been sued, the person must act quickly to begin presenting a defense. Sometimes their only chance to present a defense is at trial, when the defendant can present evidence, such as live witnesses, photos, tests, and documents. The rules of procedure in criminal and civil cases will require notice and an opportunity to be heard on many occasions, such as before each court date, for each pretrial motion, for the jury charge, and for the final judgment, just to name a few. But the big notice is at the beginning of the case when the criminal defendant gets a copy of the charge and the civil defendant gets a copy of the lawsuit. And the big opportunity to be heard is at the trial. A reasonable opportunity for appeal is part of due process, but a person does not have an unlimited right to appeal, and this might be a good way to explain some of the limits to due process. For example, if a defendant in a civil case is ordered to pay $1, the defendant cannot appeal. A single dollar is not considered important enough for appeal. Another example. If a person has their parental rights terminated in a CPS lawsuit, the person must file their appeal within 20 days. The U.S. Constitution will not protect their due process right of appeal if they wait 21 days. And the last example. In Texas, an appeal will go to one of the 14 courts of appeals before it can go to the Texas Supreme Court or the Texas Court of Criminal Appeals. But the Texas Supreme Court and the Texas Court of Criminal Appeals do not have to take every appeal. The two highest courts in Texas refuse more cases than they actually take. The Commerce Clause. When the U.S. Constitution was written, it tried to strike a balance in many ways, and it specifically tried to give the government enough power to do what needed to be done, but also limit that power to prevent the kind of abuses that strong governments are capable of. The U.S. Constitution and its amendments protect a lot of freedoms and divide power so that no one can become too powerful. It splits the power between the three branches of government, and it shares power with all the states. However, there are certain areas of governing that are reserved exclusively to the federal government, and one such area is regulation of commerce between the states. The Commerce Clause gives the federal government almost complete power to regulate commerce with foreign nations, with Indian tribes, and between the states. As the world economy has become more interconnected, and as the states have become more interconnected, the Commerce Clause has allowed the U.S. government to pass more and more laws to control aspects of everyday life. For example, because beef is usually transported from state to state for consumption by the public, the U.S. Food and Drug Administration passes laws to regulate beef production. Because TV, radio, and Internet content is shared all across the country, the U.S. Federal Communications Commission regulates radio, TV, and Internet business. And this brings us to the best example, aviation, which quickly became a matter of national concern, not just local concern, in the early 1900s. The United States Postal Service, for example, began trying to develop aviation for carrying mail across the country. Once the flying range of planes exceeded the width of most states, it became necessary for the federal government to set safety standards. But the federal government does not control every aspect of aviation. The 10th Amendment to the Constitution provides that any power not delegated to the national government nor prohibited to the states are reserved to the states. As a result of the U.S. Constitution and the American traditions, states still control some aviation laws, especially laws regarding ownership and contracts. So, if you want to know who claims to own a plane, you check the FAA website. But if you want to know who would get a plane in a divorce, you check the state's divorce laws. If a mechanic wants to register a lien on a plane for an unpaid repair bill, the mechanic files papers with the FAA. But if the owner wants to contest the repair bill, he must follow state law and possibly file a state lawsuit. If there is a plane crash, the National Transportation Safety Board will determine the cause of the crash, but state courts could determine how much money should be paid to the victims and their families. Right to privacy. The U.S. Supreme Court has said that a right to privacy is implied in the Constitution. The U.S. Constitution does not expressly say that people have a right to privacy, except it does refer to liberty in more than one place. A right to privacy would be a nice thing for people to have. But it is a strange stretch to say that the Constitution gives rights without saying it, as if the Constitution could give subtle signals such as a wink or raising eyebrows. The idea that the Constitution could imply a right to privacy came up as early as 1922 in a case called Pierce v. Society of Sisters, which is a lawsuit filed by a Catholic school against Oregon to stop an Oregon law to eliminate a lot of religious schools for young children. The judges decided that parents have a right to choose how to educate their children. It's not the way we would use the word privacy, but it started a conversation of sorts that lasted for almost 100 years so far. The idea of an implied right to privacy really came into being with Roe v. Wade in 1973. In that case, the U.S. Supreme Court held that a woman has the limited right to decide whether or not she will be pregnant or stay pregnant. I say limited because the court also said that the government had a right to protect children, and a balance had to be found between the two rights. The right to privacy was cited again in Lawrence v. Texas in 2003 when the U.S. Supreme Court decided that the state of Texas had no good reason to ban homosexual activities. As you can see, a lot of the right to privacy cases concern sexual practices and reproduction, but it has potential in a lot of other areas such as collection of internet and phone usage data and tracking a person's travels. The courts can be expected to balance the right to privacy against the government's right to know and control some behaviors for the good of the public. So as long as the government can explain it has a legitimate reason to stop the behavior or gather the information, a court might allow the government to invade people's privacy. Searches and seizures. The U.S. Constitution requires that all searches and seizures be reasonable. The U.S. Supreme Court has interpreted that to mean all searches and seizures, except for pat-downs and frisks, require probable cause, which is probable cause to believe a crime has occurred, and or probable cause to believe evidence of a crime can be found in a specific location or with a specific person. A warrant is not always required. For example, a warrant is often not required to search a car because cars, unlike houses or even people, are capable of moving very fast. The legal theory is that if an officer took the time to get a warrant, somebody could move the car hundreds of miles and it would be lost. Cases often unfold this way. An officer stops a car because it ran a stop sign or committed some other small traffic violation, and while the officer is talking to the driver, the officer smells marijuana. So the officer has probable cause to believe there's marijuana in the car, so the officer searches the car right then and there on the side of the road. Judges have said the officer can search a car without a warrant in those circumstances. A similar rule has been applied to airplanes. The logic could apply to many aircraft, except possibly hot air balloons. Here's an interesting statute. It's interesting in two ways. It kind of illustrates the problem with some laws and how they can be unconstitutional. It also illustrates the need for probable cause. The legislature recognizes that in order to search a plane, an officer needs probable cause. So the Texas legislature passed Section 24.012 of the Texas Transportation Code, which says that an officer has probable cause to search an aircraft if the body of the aircraft does not display the identification numbers required by the FAA, for example, the N number. I suspect this statute is unconstitutional because probable cause is a concept created by the Constitution, or at least embodied by the Constitution, and interpreted by judges according to the facts of each specific case. So, in my opinion, the legislative branch is not going to be able to step in and dictate what is and is not probable cause. I hope this has been helpful to you. Let me know if you have any questions.